The Supreme Court on Thursday decided to maintain the status quo for social media platforms. The family of an American student who was killed in a 2015 ISIS attack in Paris tried to claim that videos shared through YouTube's algorithm helped radicalize those terrorists. The justices declined to rule in that case. The court also rejected a separate lawsuit lodging similar claims against Twitter. In both cases, the judges did not rule on the scope of Section 230, a federal statute that reads no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. In other words, it means you can't sue Twitter or Facebook for what someone else posted on Twitter or Facebook. To untangle this, let's bring in Adam Liptak, Supreme Court reporter for the New York Times. Adam, it's very good to have you with us. Why didn't the courts rule on 230?
I think the court was nervous. When the case was argued, Justice Elena Kagan only half-jokingly said, "We're not the 9 greatest experts on the internet here." And they thought, persuaded by the tech industry, that tinkering with or limiting this liability shield known as Section 230 was a dangerous business for them to get into, and it was better left to Congress.
And is that, do you think that's going to be the case, that they'll stay away from it? And why is this such a crucial, this Section 230, why do the tech companies say it's so crucial for them?
So the tech platforms, Facebook, Twitter, Instagram, post massive amounts of data. And if they could be sued for and held responsible for what their users post, that could spell the end of the internet as we know it, or at least so they argue. Another element of the case was, well, okay, maybe you're not responsible for what your users post, but how about if your algorithms serve up more and more of what people are interested in? And that could be, as Justice Clarence Thomas wrote, cooking videos or political videos or ISIS videos, and an endless stream of ISIS videos that might help radicalize people. And the court said, so long as that algorithm is neutral, so long as it's really just giving the user more of what he or she wants, we're not going to get into it, at least for now.
And now I want to ask you about another Supreme Court decision. You were busy at the keyboard today, and the court ruled 7-2 that Andy Warhol or his estate broke a copyright law when he altered a photographic image of Prince. How did the justices explain that ruling?
So it was limited in a way. It did cut back on the fair use defense, which sometimes allows you in some settings to draw on, make use of, transform, alter other people's works. Here it was a rock photographer's photograph of Prince that Andy Warhol, in his familiar way, transforms into something different. And the court said the problem here was they were operating in the same commercial marketplace. The photographer sold her image to Newsweek and Vanity Fair. When Prince died, Andy Warhol's estate sold it to a special commemorative issue put out by the publisher of Vanity Fair, Condé Nast, and that was too similar commercially. They said maybe it's different if it gets hung in a museum. Campbell's soup cans, the court said, are different from images of Prince. But so long as there was this commercial competition, the court said the fair use defense does not apply.
Adam, as a final question, do you read anything into the arrangement of justices? So in the Andy Warhol case, you had Kagan and Roberts on the same side. So that's, in this partisan world, we don't think of that combination. And then in the social media case, it was unanimous, right? So what does that tell us, if anything, about?
Not a lot. Intellectual property, and broadly speaking, both of these things are in that realm, is not something that divides the justices along partisan lines. It's a pleasure to see that. It's great to see the Chief Justice and Justice Elena Kagan, two of the best writers on the court, together in dissent. I don't think we're going to see a lot more of that as the rest of the big cases come down in the next 6 weeks or so.
Adam Liptak, the New York Times. Thank you so much, Adam.
Thank you, John.